Start with the very first question in terms of what is the time frame for reporting a personal data breach to the data subjects under GDPR. You would have seen this question come sort of different instances. So this is what is exactly needed in the exam, right? Patience and to ensure that you read each and every word which is mentioned there, right? When we see time frame reporting personal data breach, we are so biased that immediately we jump into 72 hours, right? So the answer to this question is without undue delay, right? Similarly, if a processor has to report, right, a data breach to a controller, what is the timeline, team? Aditi, yes, answer is without undue delay. See, without undue delay means what is mentioned in the law is that the moment they come, they are aware of the breach, right? As soon as they confirm there is a breach, then they have to inform the controller as well. So you cannot spend time, or maybe you cannot make an undue delay informing the controller. So exam questions can be testing on these fronts. So I would be recommending you to look at these aspects. Whenever there is a personal data breach, try to have a broader view of what are the different questions can come from, right? Not everyone, you should not be expecting that straightforward 72 hours. Nowadays, even when you see internet, you can able to get this answer, right? But exam is not going to test you on that. Exam is going to test your understanding, how do you apply a requirement, right? So that's where I would say that you need to read the question clearly and then try to answer it. uh, which of the following is not a requirement for obtaining a valid consent under GDPR? Question number 2. So answer is C. So bundle consent is something which is not a requirement. So why I brought this question, although it's a easy question, it's a negative question, right? So this is another style of question that IAPP generally ask in the exam. Whenever you see the word not, maybe when you take the exam like this way with 10 questions, 5 questions, or 30 questions, you probably are much more tuned towards the exam, right? But when you're taking 90 questions in one go, you will also experience this fatigue, right? That's where you start making those small mistakes of not looking at the keywords properly. So this keyword of not a requirement may get missed when you're giving the exam, or maybe it comes at the 80th question, right? So that's the reason I brought this question, though a little interesting. So bundle consent. What is bundle consent? So consent should never be coupled with your terms and conditions, right? So generally people make that mistake whenever you're trying to get a consent, and a common mistake what people do is clubbing the terms and conditions with the consent, saying that I agree to the terms and condition is equivalent to consent as a lawful basis. It's entirely different. Consent as a lawful basis has a lot of difference. The reason is consent has to ensure the attributes of consent, which is mentioned here, freely given, specific and informed, and it has to be a unambiguous indication, right? So all these elements has to be explicitly stated or ensured whenever you're correcting consent as a lawful basis, right? So that's a mistake when you club multiple stuff into one terms and condition and you ask consent. That's not a valid consent, that's bundle consent. So bundle concern is what GDPR doesn't accept. Okay. So I hope everyone is clear with that. Let's go to question number 3. A company is planning to use a CCTV on its premises and it's concerned with GDPR compliance. Should it first do all the following except? So answer is A. Okay. So if you are trying to do a CCTV surveillance, right? So there is a good chance you may end up doing a DPIA, right? So CCTV surveillance falls one of the explicit triggers which requires you to do a DPIA, right? So answer B is definitely well within the requirements of GDPR. So you need to perform a data protection impact assessment. So that's a right option. So third one is create an information retention policy for those who operate the system. So this is something which is also required, because if you are trying to assess uh, the risk, you should also address this. And part of the requirement, you should generally have a clear retention period. So this is also very much an acceptable action. Ensure the safeguards are in place to prevent unauthorized access to the footage. So even part of the DPIA or in general, protecting the information with the appropriate safeguard is something which is very much required. Even in DPA, this is going to be highlighted. If there is any lack of safeguards, it's something which we have to highlight part of the risk, and then it has to be mitigated part of the DPIA, right? So that's something which is definitely required. So why answer A is not a requirement in each and every case is that, so for all the data protection, for all the data processing activity, we don't need to inform the data protection authority. Okay, so part of the earlier version of the GDPR, which we call it as 1995 directive, over there we had this requirement where each and every processing activity has to be sort of mentioned with the authority, right? Or it has to be recorded. Now that has been waived off in the GDPR. That makes there is no specific requirement for us to notify the data protection authority for each and every data processing activity, so that overhead burdens of in terms of intimating each and every processing activity has been removed in GDPR. So this makes answer A is something which is not required. Only when you see a high risk, okay, which is coming after your mitigating controls. So again, what people make mistake is, at what point I will decide when I have to notify a data protection authority. So data protection authority has to be notified, which is a mandatory requirement, when after you have identified certain risk part of the processing activity, and you will also identify the mitigation measures. So once the mitigation measures are identified and implemented, and still you feel there is a good or high amount of residual risk. What is a residual risk? A risk that exists after controls are implemented. Then probably you cannot decide what to do with that processing activity, right? So in that case, you need to reach out to the supervisory authority to take their consultation whether should we go ahead with the activity or ask them to advise on any other mitigation steps which they can implement. Otherwise, the supervisory authority may inform to stop this activity completely. So that's also a possibility that you should be aware of. That's the reason we have this requirement to notify the data protection authority. So why I'm explaining this, getting right answer is one part, but understanding the rationale, understanding the concept is even more important, because the questions will keep changing every year. So these questions are not exam questions, or these questions are not something which is there from the what to say, these are the expected dumps or something like that. Nothing like that. I generally prepare these questions from from own words. So these kind of questions get tested in the exam. Okay, so these kind of questions comes in different formats. Once you understand the logic, it becomes completely easy to get it right. So question number 4, which of the following is a special category data under GDPR? Okay, so this is a tricky question. Okay, why a biometric data cannot be a special category data? Does anyone know answer to this? Okay, so biometric data is definitely a personal data in every single instance. Okay, but a biometric data may not be a sensitive personal data. On GDPR words, we will say special category data. The catch is that biometric data, when it can uniquely identify an individual, only in those instances it may come under the category of sensitive personal data. All right, so this is something which is very important that for you to remember. Only when a biometric data can uniquely identify an individual, it becomes a sensitive personal data, right? So that's the reason answer to this question is trade union membership. Answer is D. So trade union membership always is a sensitive personal data without a doubt there, because a trade union membership can lead to identifying a person's philosophical belief or his political opinion, right? That's why trade union membership definitely falls under a special category data. Correct? All right. Let's go to question number 5. So why not B, C, and D? Because these are all operational activities, right? So operational activities is not part of DPO. So sometimes you may make a mistake that yes, DPO has to be accessible to the data subjects. That doesn't mean DPO is going to pick each and everyone's call, or DPO is going to respond to each and every data subject request. So what happens is generally we give the mail ID of data protection office. So it's not belonging to an individual, it belongs to the team, right? So what's the request from the GDPR is that you have to make the DPO accessible. So which means if you write an email to that particular email ID, your request is going to be heard or filed, right? So that means it is definitely coming to the purview of your data protection office. So that's the reason we say that making DPO accessible to the data subject is important. So that doesn't mean the DPO is going to respond to each and every customer complaints, right? Compiling records of processing activity, conducting a data protection impact assessment, it's all part of the team which he or she manages, right? So that's something we have to keep it in mind. And remember, DPO is someone who cannot hold a position which also has a role to take decisions on the purpose of processing or ways and means of processing. So if he or she does that, then it becomes a conflict of interest. Okay, so that's again very important that you have to keep it in mind. So that's why answer A, which is the direct requirement from the GDPR to ensure compliance with the GDPR and advising on data protection matters, right? Looks a straightforward answer, but sometimes when you have a scenario question, the simple words what you see might be twisted with some certain complex words, so that makes it a little difficult. Okay, let's go to question number 6. So I see a divided answer between A and D. Okay, so if you see the question, again the word except is there as a very last word. These are those tricky questions which makes you make wrong answers. So if you see what are the permissible ways which you can do a third country transfer or international data transfer. So in general we have three options. One is your adequacy decision, second is your appropriate safeguard, and third is your derogations, right? So one of the derogation is the explicit consent. So when you have explicit consent, you can always transfer the data. There is no stopping of that, right? Apart from that, you have contract, valid public interest, right? And also there is legitimate interest, which is also there, right? Now, adequacy decision is obviously with this, you can definitely transfer data. Option B is also a valid answer. Option C, by allowing data transfer only if adequate safeguards are in place. That's also a valid answer. So answer to this question uh, is answer D. Okay, using data protection impact assessment, we don't transfer the data. So why we do data protection impact assessment for transfer? I think most of the people who made the mistake might have confused with transfer impact assessment. That's altogether a different impact assessment, but this is DPIA. DPIA is done for different reasons where we have specific requirements which are mentioned as triggers for a DPIA in the law. And what we are speaking now is the international data transfer, right? So international data transfer requires three important instruments using which you can transfer data. First is your adequacy decision, second is your appropriate safeguard, third is your derogation. So DPIA is not an instrument to do international data transfer. So that's why the answer is D. For question number 6, answer is D. Kudos to people who got it right in the first instance. And people who got it A, are you convinced? So question number 7 says again a negative sentence. See, of the mandatory obligations, maintaining records of processing is a mandatory obligation. Appointing a DPO is also a mandatory obligation if their core business involves processing large volume of sensitive personal data. Implementing technical and organizational measures is also a processor. So these are irrespective of controller processor role, sort of records of processing activity, DPO and technical organization measures are common to both controller and processor, which are individual obligations, I would say, in GDPR, right? So these are all there for both controller as well as processor. Whereas if you see conducting DPIA, it's a only controller specific ask, right? a processor will only support a controller. So you should not confuse. As an organization, you will also play the role of controller and processor. Whenever you are a processor, you are only expected to support in terms of data gathering or support the completion of DPIA. The obligation of doing a DPIA, reporting it, as well as submitting when it has been challenged, this is all responsibility of a controller. So answer is D. Seventh question, answer is D. So question 7 is done. Let's go to question 8. In question number 8, there is a tricky option between A and D, right? I purposely kept the confusion area between A and D, right? If someone is choosing A, why not D? So you should be confident of that as well. That is more important, isn't it? The correct answer is A, but why not D? Actually, not really, but in the law, organization process sensitive personal data may not trigger a DPO appointment. Okay, so if you see, if your organization core business involves processing large volume of sensitive personal data, so there is a lot of depth to that particular statement to what is mentioned here. So if I just process one sensitive personal data, do I need to appoint a DPO? Answer is no, right? So the actual definition, what is mentioned in the law, is very important for you to understand. So organization core business involves processing large volume of sensitive personal data, right? So that's something you need to keep it in mind before answering this question. So that's why answer D is not the criteria, whereas answer A is definitely a criteria. Okay, so even if you are getting it right, but you need to know why option D is not the answer. So that will give you a lot of confidence in answering other questions. Okay. So question number 9: how do you determine scale? Question number 9, answer is pre-tick checkboxes are never acceptable under GDPR. Option is B. The reason is implied consent or opt-out consent is not accepted in GDPR. It has always to be an explicit consent, which means silence, inactivity, pre-tick checkboxes, all these are not accepted in GDPR. So the answer is B. Okay. So that's a pretty easy one. Whoever has sort of gone through my sessions, you very well remember that. Let's go to question number 10. So answer is C. That's perfect. So irrespective of your size in terms of revenue, organization, employees, headquarters, your extraterritorial scope only applies when you offer goods and services uh, when to the individuals in the EU or monitoring their behavior in the EU. So in fact, it's not just goods and services; it has to be a targeted goods and services. Just to add one more keyword which is not explicitly mentioned there, but it has to be a targeted goods or services. So what do you mean by targeted goods and services could also be tested in the scenario question. So you need to know what you mean by targeted goods and services. Okay. If you need to answer that question, I can explain this after the Q&A. If someone wants to understand what you mean by a targeted goods or services, or if you want me to explain extraterritorial scope, I'll be happy to do that. Okay, let's go to the final question, question number 11. So the answer to this question is answer C. Pseudonymization retains a linkability to the data of the individuals, while anonymization permanently removes the linkability. So that's the difference. So whereas the other option gives you sort of confusing words, but pseudonymization still falls under the scope of GDPR because it's only a temporary action on the data where you are trying to remove the linkability but still have a golden copy of the data, or the data can always be reconstructed to the original form. Whereas when you see anonymization, it's a permanent removal of linkability, right? We are ensuring the data can never reconstructed to the original form. So that's the key difference between your pseudonymization and anonymization. Again, it's a very important concept under GDPR. All right. So answer is C. Okay. So apart from this, I have mentioned few questions which I have not framed a Q&A type, but I felt these are the questions which are very very important, which you also need to be very sure about this before going to the exam, right? So what are the conditions for using legitimate interest as a lawful basis, right? So you should be doing a legitimate interest assessment. We call it as LIA, right? Under LIA, you need to first identify it's a valid legitimate interest, and then you have to do a necessity and proportionality test. And third, we call it as a balancing test, which is like trying to ensure that it will not be overpowered by the rights and freedom of data subject. So this is something we call part of the question number 2 also. So when do we use legitimate interest as a lawful basis? Sorry, I jumped into question number 2. Question number 1, in terms of when we use as a legitimate interest, what are the examples? And also, if can we use it to transfer data outside EEA? It becomes slightly tricky to use this as an international data transfer instrument, although it's one of the exemptions which is called out under the GDPR law. But what you need to remember is that if you're trying to use legitimate interest, you need to explicitly notify to the data subject as well as to the supervisory authority, and it can be only used on a less frequent use cases. It cannot be the most default way of doing an international data transfer. This is very very important. If we are using legitimate interest for transferring data outside EEA, these condition has to be fulfilled. Similarly, what legitimate interest assessment steps, I think I already covered that. Authority who monitors personal data processing of EU bodies. Anyone wants to give a try? What is the question answer to question number 3? Authority who monitors personal data processing of EU bodies, European Union entities. Question number 3. This shows our preparation, isn't it? That's the reason I brought these set of questions. So what is the answer to question number 3? Supervisory authority, data protection authority is all what we know who actually manages data subjects as well as controllers and processor. The question here is authority who monitors personal data processing of EU entities. You remember the word EDPS, European Data Protection Supervisor, EDPS, right? So that's the authority who monitors personal data processing of EU entities. Correct? Yeah. So that's the answer to the question number 3. So what additional information should be provided to data subject when data collected from indirect source? So question number 4, again, I would like to see who remembers this. So what additional information should be provided to data subject when data collected from indirect source? So whenever we are collecting information from direct source, you have around 7 to 8 set of information which has to be provided part of your privacy notice, right? So when you collect the data from an indirect source, what additional information has to be provided? That's the question. So the answer to the question is the source of the data as well as the categories of the different categories of personal data, right? What are the different attributes are collected from a third party source? So these kind of questions are really interesting and important. You should definitely have a clear picture in mind. Next question is, what are the different powers of supervisory authority granted in GDPR? So you have three important powers vested in GDPR, vested by in supervisory authority under GDPR. The first is your advisory role. We remember during a DPIA when you see a high uh, uh, residual risk, right? In that they have to consult the supervisory authority. So that's an example of advisory role, advisory power. The second is your investigatory power. So supervisory authority can invoke this to check or try to get access to all the documents, including records of processing activity, policies, procedures, DPIA, etc. So this is your investigative power. Third is corrective power. Whenever they feel there is some drawback, whenever they see that controllers or processor have infringed the requirements of GDPR, they may give a penalty, or sometimes they can just reprimand with a warning. So these are the different powers which are there in for supervisory authority under GDPR. When can you charge data subject for a access right? So you cannot charge any fee towards a data subject, but whenever a data subject makes repeated request, unfounded request, right, and it's clearly a motivated request, in those cases there is a provision for you to charge a small administrative fee, but this has to be clearly documented. If you're going to be challenged, you need to show on what basis did you decide it's a unfounded request, right? So controller specific obligations, we have I have emphasized this topic. Controller specific obligation and processor specific obligation, right? Doing a DPIA, doing implementing privacy by design and default, right? And also data breach notification, data subject rights fulfillment, all these are controller specific obligation, right? This is something which is very important from the exam perspective. Similarly, processor unique obligations include always working only on written instruction, which is or having a contract in place. Processor should always take a written approval before engaging a processor. This is also a unique responsibility, right? And these are something which is very specific to the processor, right? There are some common obligations which are there for controller and processor, which we discussed in one of the questions, right? So like technical and organizational measures, appointing a DPO, right? And maintaining records of processing activity. But under records of processing activity, you see a difference between the controller records and processor records, because a processor records is limited not compared to the controller records, because purpose of the personal data, retention period, the basic recipients of the data, sometimes all these things are somewhere confined, especially the retention period purpose is usually determined only by the controller. So these attributes are not decided by the processor, right? So there's a difference even in the records of processing activity fields. So this is something which you need to be mindful of. uh, Question number 9: what data subject right is absolute in nature? So any data subject rights are not absolute in nature. The reason is it has to be balanced against certain criterias, which includes your controller's legal obligation, regulatory obligation. Sometimes one's request can even infringe someone else's rights and freedom as well. So there is a balancing act which is always to be looked at. But one particular data subject rights which is absolute in nature is right to object direct marketing. When someone objects to direct marketing, there is no other option left out for the controller or a processor. They have to simply abide by it. That is the reason that's a very specific obligation that which is absolute in nature, right? 10th question also I discuss. Four-step test of personal data, which is generally the material scope of GDPR. Uh, so generally what we discuss is uh, what is personal data, right? So any information relates to identified or identifiable natural person. So this is your GDPR material scope. We also call it as a four-step test. So again, this is a very important part. So sometimes questions can test your opinions. Does it fall under GDPR? Does it also include your, for example, technology data, right? And all these things are usually tested in the exam form of scenario questions also. Can we charge administrative fee? I think the question is repeated. Sorry. Difference between Council of Europe, European Council, and Council of European Union. A very, very confusing topic. So if you have listened to my sessions, you will should be clearly thorough of. So Council of the Europe is a, if I have to say, it's a special agreement. Okay, it's a treaty actually. The people who have ratified the uh, we call it as ECHR, European Convention of Human Rights. So whoever has adopted that and signed this and ratified in the legislation, they are all part of Council of Europe. There are 46 countries and there are 27 member states. All of them are also part of this Council of Europe. So Council of Europe is a territory representation. So that's a Council of Europe. Whereas European Council, okay, is something related to the strategic body. So European Council is meets every quarterly period. It comprises heads of state. So they are not a legislative body. They come to discuss something in terms of direction of the European Union. Council of the European Union, this is also called as the Council of EU, or sometimes we call it as the council of ministers or simply the council. This is what I used to give an example of Rajya Sabha, right? So it is represented by the ministers who represents the interest of their particular member state. So this is one of the very confusing topic in chapter 1. So this is something we can keep this always in your fingerprint. If you're clear, then you can probably crack those questions. Controller specific obligations we discussed. Criteria for establishment, right? What constitutes an establishment? This is again a very important question. So we always use the word establishment. Establishment means you have to be an entity registered in the territory, or if you have human resource, or if you have technical means to do a processing activity. So there is a combination elements, not necessary always you have to be an entity registered. So that is not a specific requirement. I think there is a important court case that led to this particular verdict come from the Court of Justice of European Union. This is something which you need to be having a clear idea. Condition for extraterritorial scope applicability, which is article 32a, 32b and 32c. So whenever you are doing a targeted goods or services to data subjects who happen to be in Europe, again if you are monitoring the human behavior of the data subjects who are there in Europe, so EU, sorry, then extraterritorial scope applies. So this is something again we have discussed lot of use cases, at least 7 to 8 different use cases we used to discuss in our session. Processing of paper assets, does it fall under GDPR? It's again a very important exam question. So not all paper assets falls under the scope of GDPR. Only paper assets which are part of filing system comes part of the scope of GDPR. What's a filing system? So paper assets which are classified, which are actually having adequate security measures, which are usually part of a process, right? So ownership is defined, right? All these things gives you the clue of whether that's part of a the applicability or not. Concern attributes we discussed about it already. Being specific, it should not be bundled, and it should be freely given, and it should be an unambiguous indication, and also concern can be reversed at any point of time. These are some of the important concern attributes. GDPR requirements when data collected from indirect source, which we discussed already, the two important data sets that has to be provided. And also there is a timeline attached to that. Whenever you are collecting the data from an indirect source, when you have to give a privacy notice, you have to give within a 30 days time period, or whenever you make the first communication. This is also a very important exam topic. Different data privacy strategy that is used in notices. We have layered privacy notice. We have a concept called as your time just in time notices. We have privacy dashboards, right? And we have digital icons. So these are some of the different data privacy notice strategies. Interplay between data subject rights and lawful basis is a very very important exam topic. So as I told you, data subject rights are not absolute in nature. There are situations where data subject rights cannot be implemented because a certain lawful basis prohibits that. So that interplay is a very important chart which I would have given you part of my session. If you have joined my session, you would have seen that. Otherwise these topics are really critical from the exam perspective. And infringement that attracts highest penalty under GDPR. Any core concepts, for example your principles of GDPR, data subject rights, consent requirement, international data transfer, right? Or any instruction given by the supervisory authority or local member state law. These are the 5 to 6 instances. If you infringe that, you'll get the highest penalty. For all other aspects, you will get the lower slab of penalty. So what is a trigger for a DPO and a DPIA? So it looks very similar, but there is a good difference between DPO and DPIA. So in what conditions you need to appoint a DPO, and in what conditions you have to do a DPIA. So these are some of the very important questions which I was just drafting while for this particular session, right?